about to leave, already packing. Come with me, I'm not really asking. We'll get away to a place where we don't know. About to see the world in action, what we can be, life with no distractions. We'll get away, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free with me. Let's go, let's be free with me. Be free. Not looking back, eyes on the freeway, Bonnie and Clyde, a classic cliche. We're on the run, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free.
Good evening, everyone, and it is an evening. It's 6:30 on a Tuesday, our regular slot for our A-level law study live streams, and this is our third, I think, if I'm not wrong, for this term's series. I'm joined tonight by, well, to start with, I'll explain that in a second, by two familiar faces. We've got Robina in the middle and Dan on the right. Good evening.
Hello.
Hot foot from a long teaching day and a lot of marking to come later on tonight. So this is like a bit of light relief in a way, isn't it, I suppose?
Yeah, definitely.
Bit of fun. And so I made that rather cryptic comment at the start there, as if something's going to change halfway through this session. And it is, because we're dealing with occupiers liability. But what we thought we'd do is, because it could be quite a long session if we did it all together, we're going to split it into two, do 20 minutes or so on the 1957 Act, and then literally have an ice cream and cake break for 10 minutes before we go on to the other act. And you're going to remind me, Dan, what the other act was. Not the 1957 Act.
The 1984 Act, yes.
That's right, correct. I was just testing that you knew that. So we'll split the two acts together, but a similar mix of activities to have a go at, and also some sort of key reminders of the key content and the key cases. So don't worry about writing everything down. At the end of this longer live stream, one live stream on YouTube, we'll put the link to the slides from the whole session onto the downloads. You better go to the slides as well as watch the replay. So don't worry about writing everything down. And I'll tell you when the 10-minute break starts, because I'll need it, and Dan might need it. So who's going to start us off tonight on the first bit of the session?
Yeah, so I'm going to start us off today.
Superb stuff. Right, well, have fun, everyone, and I'll have a go at the questions as well.
Thank you, Jim. Okay, so as Jim pointed out there, we're going to split it into two today. The first one we're going to cover is the 1957 Act, so the Occupiers Liability Act of 1957. I'm going to start with a thinking activity in which you can use the chat box, or you can jot on a piece of paper should you be coming back to this a little later on. But the activity is this: so to whom specifically can an occupier of a premises owe a duty of care to? So I'd like you to identify who they are and also list the acts of parliament which provide for this. So just a little moment to pop into the chat box. So that is two things we're looking for really: the acts of parliament, we already had one already, and of course whom can they owe a duty of care to. Okay, so about 30 seconds to jot that down. Okay, so you can write that down, or you can pop that into the chat box entirely up to yourself, whichever you feel most comfortable with. Okay, right, so we'll end it there. We get the next slide, Jim, thank you. So, of course, the answers to those are to lawful visitors and to trespassers, and they're dealt with separate acts. And you see there the highlighted act we're going to go through in the first session today is the Occupiers Liability Act of 1957, but for trespassers, it's covered separately in the 1984 Act. Thank you, Jim. Okay, so of course, the thing we need to know, we're going to start with some exam gold here today. So it's important that we know the difference between a trespasser and a lawful visitor. Now, there are some things we're going to cover over these next few sessions, but the first thing we need to remember is a trespasser can begin as a lawful visitor and exceed their permission. So you can do that through area, as in Pierce and the Common Brothers, with the young lady in a circus, or through time, or through purpose. Remember the quote from Lord Justice Scruton in the case of the Calvar. So when you invite a person into your house to use the stairs, you don't invite him to slide down the banisters. And so it's that idea of you can exceed permission and become a trespasser. And if that is the case in a scenario, then of course you should use the Trespassers Act instead. Thank you, Jim. So the things we're going to cover, the key elements today are of the 1957 Act, which deals with lawful visitors, is premises, and we're going to cover exactly what premises is or are, who an occupier is, who a lawful visitor is, what the common duty of care is, how you may alter or discharge a duty of care, and finally some defences. So we're going to start with an activity, and what I'd like you to do is take a little moment to write down as many of these which you think are considered premises under the Occupiers Liability Act of 1957. So once again, you can either write the names down: house, ladder, shed, caravan, car, ship, lift, staircase, and boat, or you can simply write A1, B1, C1, A2, and so on. So once again, I'm going to give you around a minute to do that. It's not too onerous, I shouldn't imagine, and we'll reveal the answers shortly. So again, pop them in the chat if you want to. Either list them if you like, or of course write them down, and if you come to us on demand or at a later time on YouTube. So just around a minute to do that. Okay, so some comments coming in, hopefully. Try to list as many as you possibly can.
Paige is in there.
Okay. Indeed, Paige in there. Thank you. House, shed, caravan, car, ship, and ladder. Thank you, Paige. Okay, Jim, when we're ready, we're going to reveal that indeed was a trick question. All of the above are considered premises for the purposes of the 1957 Act. So this is outlined in section, this is outlined in section 13A. Okay, so we're going to look then at, strangely, the second thing, which we did confuse the order slightly there. So this was premises. We're now going to go into the next slide and consider who exactly is an occupier. So well done, Paige, your responses in the last one. So an occupier then, you would consider something normally as owners or tenants, but of course Section 1(2) of the 1957 Act tells us a person who would have been treated as an occupier in common law. So in some ways the law wasn't really helpful in deciding who a occupier was. But the two key cases we can look at, or the key case, is Wheaton E. Lakin and Co., which tells us you can have multiple occupiers. So in this case, both the brewery and the manager and his wife were considered occupiers. And of course, that concept of degree of control over premises makes you an occupier, and that was developed further in the case of Harris and Birkenhead Corporation. Okay, Jim, thank you. Now, some exam gold again. It is important that you define and apply who an occupier is of the premises. And this is necessary for both the 1957 and the 1984 Act, so we should be absolutely careful to mention it for both acts. It's also important to be able to define premises as found under section 1(3) as well.
Thank you, Dan.
Thank you.
Right, so I'm going to take the next bit now. So Dan's explained the sort of two key concepts to start off with, occupier and premises. And as Dan's just said there, please make sure you do start that with every scenario question. Will help you sort of get into your next levels to explain who the occupier is in that question and what premises are we looking for. So in order to sort of move us to the 57 Act, then we've got to make sure that these people are lawful visitors, haven't we? And you can see on the slide in front of you, we've got a variety of ways that you can be classed as a lawful visitor. So somebody that's invited in, I think that's the general obvious one, isn't it? If you have someone that you say to come round to your house to do maybe a bit of law revision for an assessment, they're invited in, aren't they? So they are somebody that is a lawful visitor. Somebody with contractual permission. So I always use examples, things like it might be that you've bought a ticket for something. So maybe you've bought a ticket to a show or a festival. That means that you are a lawful visitor in that situation, aren't you? Or maybe you're staying at a hotel. Then again, you've got that contractual right because you've paid for that hotel room. So anyone that's got that right there, generally involving money, can work quite well. Any licensees that are there repeatedly, so again you keep going back for whatever reason, and again anybody with statutory authority, so people like your utility companies who might need, so Yorkshire Water might need to come and maybe dig up a little bit of your path. They will have statutory authority, won't they, to be able to come and do that. The police as well, within their powers under PACE. So quite a variety of people there that can be considered a lawful visitor. And again, it's a good idea in the exam to sort of get to that straight away. So if it's a scenario where someone's paid to stay in a hotel and obviously they've injured themselves in the bedroom, starting straight away that they are lawful because of the fact they have that contractual permission, will again easily allow you to add up those marks. So we're going to have a little bit of a game now. So again, if you can get ready into the chat box, please. We have a 10-second countdown. So there's going to be a question that pops up on the screen in a minute. And we want to see if you can get the answers quickly into the chat within the next 10 seconds. If you are doing this on replay, again, just bob your notes in and hopefully you'll be able to see us go through it in a second. So the question is, under section 2.2, who or what is necessary to be kept safe? So who is it that we do need to keep safe there? Okay, so we've got 10 seconds.
T-minus 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. We have ignition.
Love the sound effects there, Jim. So I'm going to come back to you, Katerina, for a question a little bit later on. So right line of thinking, but yes, ratio, you've got that correct. Madison, excellent, you've got that correct. So just wait for the answer on there. Yes, so it's the visitor, isn't it? We've got to keep that visitor safe, and we include adults under there, don't we, under 2.2, and we look at other people later on. So that's why I'm going to come back to you, Katerina, because you are going to be able to use your answer in another section. But we have got to be classed as safe there. Now, the question is how safe? So it does say there under section 2.2, to what standard is the visitor to be kept safe? So again, we've got another 10 seconds. Await the sound effects. Off you go.
Liftoff will start in T-minus 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. We have ignition.
Right, let's have a look then. So we've got a few good answers here, all correct as well. So well done. Quite a lot there. Paige, Madison, Katerina, Ratio and Heber. Yes. So we can have the correct answer on, please. Yes, it's reasonably safe, isn't it? So reasonably safe for the purpose of their visit. So well done, you guys. We can't expect it to be perfect. You know, we don't all live in a show home where there's nothing out, as long as it's reasonably safe. Plus, what you have to think about there is if we said it had to be perfect, 100% safe, you're going to let everybody sue, aren't you? You're going to open the floodgates, and that's not what we want. We only want people to be able to sue who genuinely deserve to put that claim in. So well done, everybody there. You are correct. Reasonably safe is the sort of key concept, isn't it? Good. Right, can we remember the case then? So the what recent case held that trips, slips and falls are everyday occurrences. We've got to have that real source of danger. So there's quite a key case that suggested that, to suggest that the claimant wasn't able to sue, the adult wasn't able to sue there because it was considered something similar to a trip, slip and fall. So again, we'll give you another 10 seconds. Can we think of the case that told us that? Off we go.
Liftoff will start in T-minus 10 seconds. 10, 9, 8, 7, 6,
Trips, slips and
5,
falls, everyday
4,
occurrences.
3, 2, 1. We have ignition.
Right, if we have a look at the answer, then a couple of people not too sure on this one. So it was the Rochester Cathedral case under Bell, wasn't it? The Court of Appeal confirmed that there has to be a real source of danger, and you keeping your premises reasonably safe is absolutely fine. So not very good for DeBell because not able to claim, but very good for society as a whole that we're not opening the floodgates and letting everyone claim. And the best way to think about this, I always use my local area and just think, if you imagine your local area, how many sort of bits of curbstones, flagstones as you're walking around the town centre are probably raised slightly. If we allowed everybody to sue for every tiny little bit of imperfection, I think your councils would go bust, wouldn't they? So we do have to make sure that there is that real source of danger, and that knowing that just little bits of slips and trips are everyday occurrences. Okay, so keep an eye out with that case. Right, yes, it was a niche question, thank you. So the next 10-second countdown question then. So what must the damage or injury be caused by for a successful claim? So we need to think now, if we are going to sue, what are we trying to prove? What we need to think about here, okay? Again, 10 seconds, off we go.
Start in T-minus 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. We have ignition.
Sort of on the right lines there, Madison, if we just go through the answer, Jim. So we're looking at the state of the premises. The premises have got to be in a bad state, haven't they? And it is because of you breaching that duty, Madison. So almost on those right lines there. But there's got to be a problem with the state of the premises. If that danger is obvious, or you create that danger yourself, you're not going to be able to claim, are you? So there has to be something wrong with that state of the premises. Yes, through their breaching their duty. Yes, Paige, through them being negligent in some shape or form, isn't it? So yes, Yes, well done. Right, so slightly different game now. So we've got confusing pairs. If you've not played this on any of our sort of sessions before, we have the comments in the sort of pink boxes on the left. So for now it's sections. And then we have two sort of pairs on the right-hand side. And your job basically is to say, do they match? Is it correct? Or do they not match? So sort of like a true or false, I suppose. So as it says there, does the section of OLA 57 match up with the legal effect? So is section 2.3b talking about children, and is section 2.3 also talking about experts and your traders like your electricians, etc. So if we think they are correct, you can just put correct in there or true, or obviously if they don't, then obviously you might need to say that you want to move them round. So again, I'll give you a minute or so to have a bit of a read through both. So do those sections match with the text that's in the right hand side box there? So is it correct, is it true, or do they need switching? Yep, do they match, or do we need to swap them? All right, let's have a look then. Yes, well done, Madison. You came in right at the end there, didn't you? Yes, so section 2.3, we start with children, don't we? So it's got to be reasonably safe for the child. We have to be aware that the children are going to be less careful. Any allurements, again, we need to be confirming therefore. Oh, a few have come in there, good, excellent. Yes, Seba, yes, Monique. And then section 2.3b, Parliament didn't help us there, did they? They should have put them in a different section. Are your tradespeople. So if the trader is going to be hurting your house or your premise, again, we need to be aware that it has to be reasonably safe for them, although they have to guard against their risks. Just for a little bit of a bonus question there before we move on, can anybody bob in any cases? So can you think of any cases that you will have learned for children, and the fact it needs to be reasonably safe for them, or tradesmen, any traders where they've been injured as a result? Have a just think, give you another sort of 20 seconds before we move on to the next one. Any cases you might have learnt there alongside? Oh, Madison's straight in. Yes, we've got Jolly. Yes, we've got Rolls. Any others? Yes, Heber. Good case. Obviously not a good case for the outcome, but good case to use there. Glasgow Corp versus Taylor, isn't it? Phipps and Rochester. Yeah. Looks like we've got quite a few there, which is good. Yep, so we can talk about children, can't we? And we can link in Taylor and Glasgow Court with the poisonous berries, and you can use Rolls and Nathan. And yes, we've got quite a few there. Excellent. Good. We've got some good statutory authority as well as common law there. Perfect. Right, so if we move on to the chili quiz now. So again, if you haven't done this before, we've got mild, spicy and hot, and we've got the three sort of questions that are going to bob up on the next screen. If you can try and attempt all three, perfect. If not, at least try and have a look at one of them for me and bob your answers into the chat. So the mild or the easier question, how many requirements need to be proven to pass liability to an independent contractor? So if we want to pass the blame to somebody else, can you think of how many parts there is to that test? Your sort of medium question, what must we pay attention to for children? I sort of mentioned it a little bit there. If you can give any examples of things that we have to be sort of more cautious of because of the nature of children. And then lastly, sort of your more difficult question, what are tradespeople expected to guard against? And then can you give any examples? So obviously we've looked at roles. You can use the example in roles or any other sort of risks that you can think of there. So again, we'll give a minute to bob anything in. If you're answering the question, if you maybe just put 1-, 2- or 3-, so I can see which one you are tackling. So I'll give you a minute for that because there's quite a few different questions on there. You've got something there, Paige. I'm just not sure if you've got the right number. Madison's put something in. Yeah, can you think of any special risks? think of any jobs like electricians, plumbers, what risks they might have to check against. Ah, there you are, Paige. Yeah, you've corrected yourself. Excellent. So last 15 seconds. Right then, let's have a look. So we've got some quite good answers there from Paige and Madison, so well done. So yes, we've got the 3, haven't we, part test there to pass on to the contractor. If we can, great, you won't then be liable, we'll blame the contractor instead. And you might remember the case of Hasseldine, that's one where we sort of refer that to. What must occupiers pay attention to for children? So Paige got it straight away, didn't you, Paige? Yes, so any allurements. And again, think of any examples of allurements. Children love shiny things. They love food, don't they? Anything that they can get their hands on, really, that's within reach. So you can have a think of the variety of different things you could use there. And yes, definitely, Madison, you are correct there, aren't you? So with the chimney sweeps, it was the issue with the poison that they needed to be aware of. Electricians, it's cables, isn't it? Plumbers, water. So any sort of trader that's coming into your premises, thinking about that, although you have to make it reasonably safe, they've still got to protect themselves, haven't they? They can't move all that blame on you. They still need to check things are going ahead as they should be. So yes, very well done there, people. Right, so I'm going to pass back over to Dan now for the last section.
Brilliant. Thank you very much, Robina. Plenty of good activities there, plenty of good answers coming in. Hopefully that can continue now. This game is something you might do in class. So what you're trying to do is beat the teacher. And in this activity, there are some deliberate mistakes. So I put some deliberate mistakes in on the next slide. What we need to do is read through the activity. I'll read through it first, then I'll give you 2 minutes to try and identify any of those mistakes. So we're going to spot the errors. So this again is to do with independent contractors. And so the question is, the statement is, if the fault on the premises is caused by the negligence of an independent contractor, the occupier may be able to pass on the claim to the independent contractor and be absolved from liability under Section 3 of the Occupiers Liability Act of 1957. Now, 3 requirements are necessary for this. Number 1, it must have been unreasonable to have given the work to the contractor. The contractor must be incompetent to carry out the task. Number 3, the occupier does not need to check the work themselves or have an expert check it. So what I'd like you to do, as you've been doing in the chat already, is try to identify any of the errors and place in the correct answers where possible. If you could, list the error and what the correction is. Okay, so about 2 minutes to do that, please. Just pop it down. And again, if you're doing that at home, you're doing it at a later time, just write the answers down, pause the video, write your answers down, and then of course check them when the answers pop up. Okay, Paige is coming in. Reasonable, not reasonable. Contractor must be able to carry out the task. Occupier must check the work done. Some good answers there, Paige. Thank you. Abdu, we're glad you think it's a good lesson. Hopefully it can help you achieve the best you can.
We've got some 84 coming up as well, Abdu, later, so stay tuned.
Absolutely, yeah. With me, sadly not Robina, but we'll have Liz joining us, won't we?
Yeah.
So just about 1 minute left for that, if you don't mind, pop in your answers. So Paige, I would say there's probably one more you need to get, if you don't mind, so try to find what you think that might be. Okay, so Monique, reasonable, competent. Again, one more from you, please, Monique. But the 3 really good answers. Well done. Okay, so I'll make that about 20 seconds left on this activity. So try and get those answers in the comments box or on paper, like I say, if you're doing this at a later date. Okay, now if we could, let's see what the errors are. There's probably one that is missing. So most people who've commented have correctly identified the mistakes in the 3 requirements. Unreasonable, incompetent, and does not need to check the work themselves. But nobody so far has noted that section 3 is a mistake also. So can we have the correct answers, please, Jim? Okay, so the correct answer for that one is section 2, subsection 4 of OLA 1957. But of course, Monique and Paige have identified correctly. Reasonable is it must be reasonable to have given the work to the contractor. So what this means is obviously they are qualified to do the job. The contractor must be competent to carry out the task. There are many ways you can check this. And of course, occupier must check the work done where possible to do so. So of course, it must be possible, but they've got to inspect it to check that it is done correctly. Okay, thank you very much. And we're going to pass over to Rabina for the very final activity.
Yes, so the last little bit, again, quite key for scenarios is this one. So thinking about any possible defences that could either reduce liability, so you might pay less in damages, or even completely remove liability so that you don't pay any money whatsoever. Often these will come up in scenario questions that you might be able to use then when you are looking at someone's liability. So 30-second challenge now. Can we list as many defences in the chat as we possibly can? So final last activity now. Give it everything in that chat. Off you go. As many defences as you can think of. Madison's in there.
Yeah, well done, Madison.
Last few seconds, everyone.
Madison, perhaps one more. Oh, well done, Rachel.
Yes, let's have a look. Oh, Monique's just come in there as well. Excellent. Monique's just got the last bit as well there, haven't you? Yes, so contribution negligence, quite a key one, isn't it? If they've contributed to their own injuries, we will potentially be able to reduce that liability there. We will be able to drop it down. Warning notices, Monique's just coming there with warning notices. Fabulous one there to point out. Again, just make sure in the question that the warning notice is effective, because it does need to warn you of the danger, doesn't it? Just saying no entry, that doesn't work. That's more for a trespasser. So does that notice actually warn them of the danger? Again, can provide a full defence there, as can exclusion clauses, removing liability with you saying you're not liable for any sort of damage or sort of any sort of theft, etc. We often use them in car parks, don't we? I always talk about sort of big shopping centres. It's always there so that they're not liable. And then, yes, consent, or you might have learnt it as volunteer, either way. But if they fully consented to all the risks that are associated, again, we can completely remove liability there, can't we? So out of all those, contributory negligence is the only one that the damages will reduce. It is possible to reduce to 100%, but generally they will reduce down, whereas all your other defences there will provide you sort of with no liability whatsoever, won't they? Full defence. Fantastic there. And again, if we spot them in a question, please make sure that you do refer to them in your knowledge and that you apply it in that question. So
Fantastic.
That's it. First one done already.
We are halfway through our mega session on occupiers liability. We've done 1957 and we're going to hop forward to 1984. And I can see that Liz is joining us in the screen. So what we're going to do is we're going to leave the live chat and the stream running. And I'm going to play some sick beats for 10 minutes. We'll do a countdown, give Rabina a chance to go do some marking, Dan a chance to quickly go over his notes on the 1984 Act. And we will be back in about 10 minutes' time for another 20 minutes or so, 25 minutes of activities on the second part of occupiers liability. As I say, we'll leave the live chat open, so if you want to type some questions in the live chat, we'll try to pick up on those. We'll be around. And maybe, I'm guessing everybody, all your mates will want to drop everything they're doing now when they hear that there's another part of the live stream still to go. So, yeah, text all your mates and join us again in 10 minutes. For now, though, Rabina, many thanks.
Yeah, no, thank you very much. And thank you, everybody. Well done on that. Very good participation. And if you are doing this at home, as Jim has said a couple of times, don't forget you can download everything afterwards. Dan kindly created the resources for this, so you can thank him. All right. See you later, everyone. Bye.
Yeah, cheers. Right.
Thanks,
Okay, we
Rabina.
shall see everybody else in 10 minutes' time. So just go take a break and then we'll be back for some more fun in 10 minutes.
All of the snow in this winterland used to look so pretty, now making me moody. In the deep woods, alone with my fields, spend too much time thinking. In the end, you'll be with me. Maybe I'm just getting it now. Damn, I took a little time out. Demons really catching up. Honey, what if there's no meaning? Oh, my heart is slowly bleeding. You
There we go. Press pause. So I just flipped on my my Spotify playlist for A-level law live stream intermissions, and that was the first time I've ever used it. So welcome back, everyone. This is the second part of our live stream on occupiers liability, and the eagle-eyed amongst you will notice there's been a change of personnel. Not on the right, where Dan is still with us, but Rabina has stepped out of the hot seat, and in her place is Liz. So good evening, Liz.
Hi, everybody.
Great to see you. And again, many thanks for taking some time this evening. For those of you joining live, I know, Liz, you've been really busy along with the rest of the team. So we've got about, 25 minutes or so left looking at the 1984 Act. Same drill as previously, a series of activities for those of you joining us live. And I can see there's still quite a few of you with us for the live stream. Have a go in the live chat. If you're watching on catch up and replay, obviously can't use a live chat, but please, press pause, write your answers down, and then see how your answers compare with the responses that Liz and Dan do. Don't forget, at the end of this, I'll post a link to where you can download all the slides from tonight, the whole session, both sessions. So don't worry about writing everything down as we go. Are we ready to start? Who's going first?
Me, for purely introductory purposes. So welcome back, those who just done the 1957 session. We are now going to move on to the 1984 session. So we have the first slide. I'll hand you over in the capable hands of Liz.
Fantastic. So if we move on to the next slide, here we go. So the first activity for this session on the Occupiers Liability Act 1984 is a starter activity thinking about the differences between the two statutes. So if you are watching this along live, you can pop some comments into the chat. That would be great. So what differences are there? Can you tell me some of the key differences between the two statutes? A bonus question also, if you wanted to pop any answers into the chat, would be, are there any similarities between the two statutes? So there are two separate statutes for occupiers liability, the 1957 and 1984. So the first comment, someone named Ratio, like it, 84 protects unlawful visitors, 57 is about lawful. So absolutely fantastic. So the really big key difference about these two statutes for occupiers liability is that the 1957 Act, as you will know if you've just done the earlier session, the 1957 Act legislates and provides a statutory framework for lawful visitors onto premises, and the 1984 Act protects unlawful visitors known as trespassers. So that is the really, really big key difference, and that's really, really important when you're in an exam question, you're looking at a scenario and you're working out, actually, is the person who has the claimant who has entered the premises, are they a lawful visitor or unlawful, because that will determine which statute it is you refer to. Madison, again, has said lawful visitors versus trespassers, so very well done. A couple of other key differences which are really, really significant. For Occupiers Liability Act 1957, the scope of the duty extends to kind of taking reasonable precautions to protect visitors from personal injury or property damage. Now, you can only make a claim under the Occupiers Liability Act 1984 in relation to personal injury. So the nature of the duty is much narrower for the 1984 Act, and that reflects the fact that actually they are trespassers. So some people, every time I teach this to students, right now we're going to look at the duty of care that's owed to trespassers. They say, why do you owe a duty of care to trespassers? They're trespassing. Surely you don't owe them any duty. Occupiers do owe them a duty. However, it only extends to kind of taking reasonable steps and reasonable care to prevent foreseeable personal injury. So the final key difference, which is really, really important, is that the 1957 Act, the duty is automatic. So the 1957 Act establishes that an occupier of premises does owe a duty of care to lawful visitors to their premises, and that is known as the common duty of care. So the 1984 Act actually doesn't automatically impose a duty of care to trespassers. So occupiers don't automatically, in every single circumstance, owe a duty of care to trespassers. It establishes a three-part test to determine when a duty of care can be owed. So that's quite a significant difference. So if you are, some of you maybe that are watching, an occupier of premises, then you do definitely, according to the 1957 Act, owe a duty of care, the common duty of care, to all lawful visitors. The 1984 Act outlines a 3-part test which determines if you owe a duty of care were any trespassers to come onto your premises and suffer personal injury whilst they were on there. So well done. We shall move on to the next slide. So a little bit of exam guidance here, and this applies to any scenario-based question, irrelevant of whatever exam board you're studying. So in an exam scenario, now, when you're looking at a scenario question, sometimes students often say to me, how do you know if it's just standard negligence, or how do you know if it's occupiers liability? So what I would say, always say to students, is that negligence is when you kind of look at the actions of the defendant in breaching their duty of care, whereas occupiers liability is arises when the breach occurs due to the state of the premises. So the danger is created by the state of the premises for occupiers liability, whereas for standard negligence, the danger is generally created by kind of the action of the individual. And it is a really fine line, because ultimately, even if it is just standard negligence, it's probably taken place on premises. So, or it may have taken place on premises. So just because something is on premises doesn't automatically mean that it is occupiers liability. It falls under occupiers liability if the danger is created by the state of the premises. But look out for visitors that become trespassers, and this is really, really important. So when people, students, think of trespassers, they think they're looking out for somebody who's like unlawfully breaking in, or has kind of looked at a trespasser sign and thought, oh no, I'm going in anyway. But actually, visitors can become trespassers by the nature of their kind of permission to be on the premises. So you may well have permission to be in a building for one purpose, but if you enter for a different purpose, then you may enter as a trespasser. You can be a trespasser in one part of a building and not another. So it's really important to actually think about, do they have a lawful right to be there? They don't have to kind of have entered illegally necessarily, or in a typically illegal manner to be a trespasser. Is, do they have the lawful right to be on those premises? So remember, really important, that if they are a trespasser, they can only make the claim for any personal injury they suffer. If they suffer any property damage, that won't be covered under the 1984 Act. So the next activity is the big reveal. So can you work out what is hidden behind the question mark before all the clues are revealed? So what we will do with this activity is we will show 5 clues, and then as you go along in the chat, pop what you think the answer might be. So the first clue, okay, it's a case. So it's a common law authority, a case that concerned occupiers' liability towards trespassers. So we've got a good range of cases. There are some cases within the topic of occupiers' liability that you can use for both the 1957 Act and the 1984 Act. So, for example, Wheat and Lacon & Co Limited, you can use as the authority for occupier for 1957 and 1984. However, there are some cases which just fall under each of the separate acts. So pop any case names that you can think of about the 1984 Act into the chat. And if you're watching this on catch up, you can pause the video, you can have a discussion, you can list as many as you can think of. Clue number 2. Okay, it was heard in 1972. So the more eagle-eyed view may be thinking, okay, well, 1972, that's before the 1984 Act. So how's that going to be relevant? And this is actually a case which is really, really significant and relevant to the 1984 Act. So if we reveal clue number 3, okay, so in this case, the claimant was a 6-year-old boy who was electrocuted when he wandered from a park onto a railway line through a broken fence. So this was a case where the claimant suffered severe burns. He wandered from this park onto the railway through a gap in the fence, which people kind of frequently went through, and the defendant actually knew that. So clue number 4 is, so the defendant was aware of the broken fence for several months and did nothing about it. So this is where we start kind of thinking about like fault, and we start thinking about blameworthiness, and think, well, actually, even though the claimant has potentially trespassed, the defendant knew that there was a broken fence and did nothing about it. Okay, number 5, clue number 5. The House of Lords used a practice statement to overrule Addy and Dunbreck to allow a common duty of humanity to trespassers. So some of you have got this, so well done. The answer is dun, 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 BRB versus Herrington. So this is a really significant case, not necessarily one that you might need to use in an application question, but part of the context of kind of how the 1984 Act came about. So typically, according to Addy versus Dunbreck, there was no duty of care owed to trespassers by the occupiers of premises, but in BRB versus Herrington, the House of Lords used a practice statement, and we know they didn't, Supreme Court also don't use it frequently, or similar powers. They didn't use these powers a lot. So this is a really significant case. The House of Lords overruled their own previous decision to say that actually there was a duty of care in relation to personal injury owed to trespassers of premises, in this case children. Okay, so well done if you got that. The next one, so it's just to kind of clarify the elements of the Occupiers Liability Act 1984 in relation to trespassers. Quite often, what I find when I teach this to students is that they kind of get all the different aspects of occupiers liability, but find it really challenging to kind of go through it and structure it in an application question. And this is often because occupiers liability tends to get taught after negligence. Negligence is really nice and straightforward. Duty, breach, damage, you work your way through those three elements. It's quite straightforward. Students really grasp that well. Then you get onto occupiers liability, and it seems like there are lots and lots of different elements to go through. And on top of that, you've also got lots of statutory references and section numbers and different, really wide range of case authorities. So try and think about this 1984 Act as having 6 key steps. Okay, so if you are going through it in an application question, explain and apply what is meant by the term occupier, then explain what is meant by a trespasser, apply, outline the scope of the duty, that it just relates to personal injury with dangers created by the state of the premises. Step 4 is then going through the 3-part test and applying it to the scenario that you're presented with. So going through the 3-part test and determining actually is the duty effective in that scenario. Step 5 is then going through whether or not the duty has been discharged. So has the duty of care been fulfilled by the occupier of the premises? So this is kind of thinking about have they discharged the duty, or has the duty been breached? You could also talk about kind of warning notices, so they can discharge their duty if they have got a sufficient warning notice. And then you can finish Occupiers Liability Act 1984 by thinking about, are there any relevant defences which you may wish to discuss within this context? Okay, so I will now pass you over to Dan for a few more activities.
Thank you. Some excellent input there from Liz. So you should find these really easy. So we are going to start with a true and false activity. So what I'd like you to do, if you're at home, you can obviously write this down, pause, and find the answer afterwards. But if it's true, pop your answer true in the box. If it's false, please say false. But also, can you give me the correct answer, or can you correct the misconception? So the first true or false question then, we've already got an answer, that's brilliant. The test for premises under the 1984 Act is the same as the 1957 Act. So I'll give you a moment to try to pop your answers in the box before revealing. So thank you, Madison, for that answer. Okay, so we will reveal the answer now. That is, of course, true. It's exactly the same test for premises as it is under the 1957 Act. So if you have been involved in this whole session, you can rewind back and go to the part on premises and look at the law surrounding that. For the next one, trespassers can claim for personal injury and damage to property. So once again, can you write true or false? And if it's false, what is the correct answer instead? So just a moment to do that. So trespassers can claim for personal injury and damage to property. Okay, so can we reveal our answer? It is, of course, false. As Liz correctly pointed out a few times before in her explanation of the law, a trespasser can only claim for personal injury. Section 1, subsection 1 of the Occupiers Liability Act of 1984 does only refer to injury being able to be claimed for. Okay, and the next one. One can become a trespasser if one exceeds the permission of the occupier. Again, is this true or is this false? So once again, you can pause this, write your answer down, or you can pop inside the chat box whether it's true or whether it's false. Okay, thank you. Let's reveal the answer. It is, of course, true. Okay, so you can exceed your permission and become a trespasser through area. So, for example, going somewhere you're not allowed, as in Pearson and Coleman Brothers, where the young lady went into the circuit, or part of the circuit she was not allowed. Time, of course, we can exceed permission or for the time we're allowed in a particular place, or indeed the purpose. And again, refer back to the comment from Lord Justice Scruton in the Calgarth, referring to the stairs and banister, the difference between being invited to do one and not going on the other. And of course, we can refer to Tomlinson and Congleton and Borough Council as well for that. So the next one is always a trespasser if the occupier wishes for them not to be on their premises. So is this person always a trespasser? Is a person always a trespasser if the occupier does not want them to be there? So again, Madison has put an answer in. That's fantastic. Thank you. If anyone else would like to pop in an answer, do that quickly. We're about to reveal the answer. And it is indeed false. So there are, of course, certain classes of people who will always be visitors and therefore not trespassers. So these can be licensees. Again, something Liz and Rabina in the previous presentation dealt with. So licensees, you can have express or implied permission if the presence has not been objected to. And of course, you can have a statutory right. So people like your meter readers from the gas or electric company. And if a police officer was exercising a warrant, yes, Mr. X, thank you. So if police was exercising a warrant, of course, they're not going to be a trespasser if they have a statutory permission to be there. Okay, thank you. Next one. So one can exceed permission through time, space or area, or through the purpose for which they've been invited. So is this true or is this false? Okay, quickly get your answers in. We're about to reveal the correct answer. Okay. And it is indeed true. Indeed, I referred to that in the previous question. Okay, next one. Thank you, Madison, again. This time, the state of the premises must be the cause of the personal injury. Is this true or is this false? This one, straightforward, I think. Thank you again, Madison and Monique. Brilliant. It is, of course, true. So it's nothing else but the state of the premises needs to be the cause. And remember, we need to keep the premises reasonably safe. Okay, thank you very much for that. Now in this next one, we're just going to clear up the scope of the duty. And so what we're focusing on is the three things must be proven in order for there to be a duty in existence. So the first one under section 1 subsection 3 of OLN 1984, the following must be met for a successful claim. So the first thing is section 13A, the occupier is aware of the danger or has reasonable grounds to believe that it exists. So this is an obvious one. If it's visibly clear, then of course we're aware of the danger. But reasonable grounds could be something like we know there's something not quite right with our property, but we're sort of ignoring the problem or not having the problem fixed. And that would cover section 13A. In section 13B, this is where the defendant knows or the occupier knows or has reasonable grounds to believe the other is in the vicinity of the danger concerned or that he may come into the vicinity of the danger. In either case, whether the other has lawful authority for being in the vicinity or not. So in this particular case then, in this particular section, 13B, we're looking to see, does the occupier know the others in the vicinity? So if you know people use your land as a shortcut, or you know teenagers regularly break onto your property, then you have an idea that somebody's either in the vicinity or going to come near to the property. So this is demonstrated in White and St Albans City Council when the claimant was injured in this case using a car park shortcut, but the occupiers had no knowledge that the car park was ever used for a shortcut, and there was a shortcut used, and indeed it was blocked off. So they had no reasonable grounds, so the claim was not successful. And looking at the final issue, section 13C, the risk is one against which in all the circumstances of the case, he may reasonably be expected to offer the other some protection. So a lot of factors can be taken into account here, such as, for example, time and date. So we look at Donahue and focus on properties. This was a person diving into the harbour late at night in the middle of winter. Now he broke his neck, and the claim against focus on properties in this case wasn't successful because, of course, they couldn't reasonably expect it to offer protection in the middle of winter for someone diving at shallow tide in the middle of the night. So we have a situation there where it's not reasonable in those circumstances, and that can also lead to the idea that most claims are found in favour of the defendant, and there's good policy reasons for that. Okay, on to the next slide, please. So another piece of exam gold, another nugget for you. So it's important here that you can define and apply each part of the trespasser three-part test. So what we've just been through now, the idea that you need to be aware of the danger, know of the vicinity, and is it reasonable to offer some protection within those circumstances. We need to make sure all of them are applied. If any one of those tests fails, then the claimant will have no claim. Now, you will be used to this if you do, and you're familiar with negligence, for example. Okay, thank you. And now we're going to do a short thinking activity. And again, what I'd like you to do is take 1 minute and type your answers into the box, or again, if you're home, pause and write in those responses. Now, the following cases all illustrate one concept with respect to the Occupiers Liability Act of 1984. What I would like you to do is tell me what it is. So the cases are Ratcliffe and McConnell, Donahue and Folkestone Properties, and Tomlinson and Congleton Borough Council. So all those cases demonstrate one concept. They have a link between them. Can you write down on paper, or indeed if you're live in the box, and find out and give me the idea? Okay, so not quite correct, Madison, there, but that's a good attempt. So we can keep popping our answers into the box. So there's about 30 seconds. Try and get that into the box, please. Okay, 10 seconds. Any final answers? Pop those into the box. Okay, actually, Madison, you're sort of in the right direction there, but still not quite right. Okay, the next one is actually then the concept here we're talking about. This is the concept of obvious dangers. Now, of course, if there is a warning, as Madison has pointed out, then that would become an obvious danger. Not quite Monique as well, but so we have obvious dangers. Now, an occupier will not normally be liable in these situations where adult visitors are concerned. And we have a quick question there, why? And of course, the answer to this is that the claimants in each case lacked personal responsibility. So you can't, in a sense, be reckless and then claim against somebody when you're a trespasser without good reason. And this is, of course, a policy decision to narrow the amount of people who can make claims under this act. Okay, thank you very much for that one. Now, in this one, what you need to do, and you've had a similar activity if you've been with us all evening here, is you need to list which of these factors will be taken into account when considering whether the occupier took reasonable care in the circumstances under the Occupiers Liability Act of 1984. So we've established a duty in a sense. We're now saying, have they breached it in a sense, because we're looking at whether they've taken reasonable care. So what I'd like you to do is list as many as possible into the box from these. So we've got warning signs, cost and practicality precautions, age of the occupier, effect only on the occupier, likelihood of trespass, how many times the trespassers come to the property, defences, how upset the occupier is, attractiveness of the danger, the damage caused, obviousness of the danger, common sense, reckless behaviour of the occupier, seriousness of the injury, visibility of danger, and of course, age of the trespasser. So list as many as you can of those into the box, into the chat box, or indeed note them down and pause this video if you are not live, if you're joining us later on YouTube or through Tutor to You. So as many as you can, pop them in the box. Mr. X, reasonableness. Okay, thank you for that answer. Okay, try to make sure we, as much as possible, match the phrases in the box. So of course we're looking at how will this judge how reasonable it was, or how reasonable care was in this particular situation. Okay, so about 1 minute to finish this activity. Don't forget, put down as many as you possibly can. And if you're looking for a particular target number at this stage, the correct number is 8. So we're looking for 8 of those which will be taken into account or could be taken into account when looking at whether reasonable care has been taken. So about 20 seconds left on that activity. Okay, and if we'd like to reveal the correct answers, please, Jim. Here we are. So the ones you can see in yellow are indeed things we may take into account when assessing whether the occupier has taken reasonable care. So some of these you might seem quite similar to in negligence, and of course this is sort of an extension of that, so some concepts will overlap. So we look first of all at cost and practicality of precautions. Well, only reasonable precautions will be required, and of course Mr. X before has noted reasonableness, and this will kind of link towards that. Of course, common sense. If somebody's not used common sense, then they're less likely to have a successful claim, and therefore the other person has taken reasonable care. Now, the age of the trespasser, the younger the trespasser is, more care needs to be taken, but if the person is an adult, then we don't need to take any particular extra care. Now, if the danger is an obvious one, then this can be taken into account. If there's an obvious danger and you've taken reasonable care, then of course the claim is less likely to be successful. The same as visibility. So this is linked very much to obviousness under section 318 of the Act, which talks about personal responsibility and the fact obvious risks should not really be a basis for a claim where adults are concerned. In terms of seriousness of the injury, the more serious the injury, perhaps more care should be taken, but again, this is only one factor. For attractiveness of the danger, then we need to take steps to avoid it. If it is attractive, and this is particularly where children are concerned, and the concept or extension of the allurement principle. And finally, likelihood of trespass. So if it's more likely to satisfy section 13B, because there's more awareness of the likelihood of trespass, so we do need to be taking this into account in terms of whether reasonable care has been taken. Okay, thank you for that. Well done, everybody. And the next activity from me is a 30-second challenge. So in this case, you might have already seen this similar activity in the previous stream. What we'd like you to do is list as many defences or things which may remove or reduce liability under the 1984 Act. Okay, so if you could you pop them into the box, and your time is about to start. Get those answers in the box. Okay, so just wait for a couple of moments to see if those answers are coming through. So we're looking for as many defences. Thank you, Monique. We've got contributory negligence, Valenti, exclusion clauses, Madison, the same as the 1957 Act. However, exclusion of liability isn't expressly forbidden by the Act and may well be used. That's an absolutely brilliant answer. If we could reveal our answers, they are indeed exactly the same. So contributory negligence, warning notices, exclusion of liability, it isn't express, but it's not expressly forbidden either. So there is a possibility it could be used, but there's very little case law on it. So that's why we are in two minds, really. And of course, Valenti, has the person consented to the risk? Okay, thank you very much for your participation in those activities. For the final activity, we're going to pass over to Liz.
Okay, great. So the final activity is another 30-second challenge. So the final one is a case challenge. So in the next 30 seconds, what I want you to do is pop as many cases as you can into the chat. Now, this can be 1957 cases or 1984 cases. So any occupiers liability cases that you can think of, as many as you can. Pop them into the chat. So 30 seconds starting now, please. Left. You can think of as many case names as you can, pop them into the chat. That would be fantastic. So 30 seconds is up. Thank you, everybody who has contributed answers. So there are some really key cases. Just a quick couple to mention, just right at the end here. So cases like Wheat and Lacon and Co Limited, which is our case about what is an occupier. That's a really good core case that you can use for both statutes, 1957 or 1984, and it's one which you can mention right at the beginning of occupiers liability. Because you can talk about it when you're discussing who is the occupier of premises. There's a really wide range of cases for each of the different aspects of the 1957 and 1984 Acts. Madison's popped a lot of names into the chat, so well done, Madison. Your case knowledge is obviously really good. And just a final thing that I would say is that with occupiers liability, in order to kind of access the highest marks in an exam, what you want to be able to do is cite key cases for specific points and individual section numbers. And whilst you don't have to learn the entirety of a particular statutory section, actually kind of learning off by heart some kind of key phrases from within those provisions can be really beneficial. And that takes us to the end of the activity. So thank you very much, everybody, for joining in.
Fantastic.
Yes.
What a marathon. We've done an hour and 5 on occupiers liability with 10 minutes of intermission and break and some sick music in between. But that is fantastic. Many thanks to everyone who has been with us for the whole session. Looking at the live stats here on YouTube, we've had lots of people join us for quite a lot of the session, then go away and then come back again. But a small number have been with us all the way, which is phenomenal, particularly Madison, who I think has been with us from about 10 minutes before we started. So well done, everyone who's joined us live. What did you think, Liz? Dan, amazing contributions and lots and lots of, particularly on the case ideas, there are lots of great knowledge as well.
Yeah, absolutely. I think across both sessions, some really good input from students, and hopefully those who haven't engaged online today will benefit from this in future. So just make sure you pause the video, and you are honest with yourself about whether you kick those answers or not. But yeah.
Fantastic stuff. Well, as Dan mentioned and Liz did during the session, what we'll do when the live session is ended in a minute or so, later on tonight, YouTube processes that, makes it available pretty quickly. We'll post a link to the slides in the comments box of the YouTube video, so that'll be there forever. You can go then download the slides and maybe add some the exam gold ideas, the key summaries, the key points. Great stuff for maybe printing off or just adding to your notes. Really useful stuff. And of course, don't forget, you can also go back and look at all the other live streams we've done for A-Level Law, not just the ones in this series, this term, but also earlier in 2021. Lots of amazing stuff with Liz and Dan and the team, Rabina and Sarah and Gemma and the team. Fantastic stuff. check it out at tutor2u.net/live. We're almost there, except to ask for one more thing, please. If you're watching this live and if you're watching this on replay, if you found the session useful, please give it a thumbs up, because that will make Liz and Dan's night. And if you didn't find it useful, then please just give us a thumbs up, because that will also help. That will help YouTube suggest this session and others like it to other A-level law students. Amazing. Liz, Dan, thanks very, very much for because I know you're really, really busy, and it means a lot to us that you've taken some time to help us out. Thanks to Mr. X and to Madison and the team on the live chat tonight. And we'll see you. It's a regular slot, so next week we're back with just a half-hour session. But it's a regular slot, 6:30 on a Tuesday, and I look forward to catching you on the next Law live stream. Dan, Liz, many thanks. We'll see you all later.
Next one. Thank you. Bye.
Bye.
Cheers.